Good morning, everyone, and welcome to day 3 of our Client Appreciation Week. We are thrilled to have you join us today for today's webinar, HR Compliance Updates. I'm Ashley Smart, the Director of HCM Services here at Dominion Payroll, and I'm joined by my colleague, Josh Ard, Director of Business Development with Boost HR and DP Assist. Josh is a SHRM certified HR professional and trusted advisor with extensive knowledge of state and federal employment compliance, labor relations, policy implementation, OSHA training, and HR software solutions. We're excited to speak to you today on the latest developments in employment laws, regulatory changes, and compliance best practices to ensure that your business is fully prepared for 2025. But before we begin, just a quick reminder that today's session will be recorded and a copy of the recording will be sent following our presentation. If you have any questions during our presentation, please submit them in the questions chat and we'll be happy to address them at the end of the presentation. If we don't get to all of your questions during the webinar today, don't worry, we'll be sure to include them with the presentation recording email. With that, I'll hand it over to Josh to get us started. Josh, take it away.
All right, I appreciate it, Ashley, and thank you also for everyone who has joined us today. We have had an excellent client appreciation week so far, so we're looking forward to continuing that. But without further ado, we'll go ahead and jump right in. Just a small agenda for today. What I wanted to do is touch on the importance of HR compliance for owners and managers. Anytime that we talk about HR compliance on the federal and state level, I think it's critical to just reiterate the importance of the managers and supervisors and their role to ensure proper compliance. We'll also look at the FLSA salary threshold increase for overtime eligible employees, specifically salaried employees. Also, we'll look at a few federal HR legislative updates that occurred during 2024. Talk about what is the Chevron doctrine or Chevron deference. And then also we'll look at a few things or trends to expect during 2025. Let's jump right in. As far as takeaway goes, we have a lot of information to cover today, and as Ashley mentioned, we will provide this presentation to all attendees following the webinar. But a few takeaway goals that we wanted was just to gain an awareness of the complexities of HR and employment law. I think that that's half the battle sometimes. Sometimes there's just not an appreciation of how complex HR can be and what our roles are, in that practice to ensure that our company or organization is going to be compliant. Learn the importance of HR compliance to build and sustain a healthy company culture. We're in a time right now where employees are more aware of what is to be proper HR or their interpretation of proper HR. So this means that as managers, owners, supervisors, we really have to be on our game. And ultimately, with that knowledge and appreciation or awareness, then we can expand your ability to confidently advise and manage your employees. It's always better to approach a situation when you understand the ramifications or the repercussions of improperly going about it. So, and ultimately, we want to protect, you as HR representatives, as managers, your employees, and your organization from HR risk. I use a phrase all the time that HR doesn't make us a dime, but it can cost us a fortune. So with proper HR compliance, we have found that companies and organizations can be far more efficient and be successful, as a company. Just to kind of start off broad, and I know I'm preaching to the choir here, but there's when talking to our clients, there's often a misunderstanding, in many aspects of HR, but just what exactly is employment law compliance? We're in a time right now where, decades ago there were not the federal and state legislative measures that we had to adhere to as a company. But it seems now that, every aspect of the employment relationship is governed in some regard. We actually talk to clients sometimes too about, compliance in recruiting or trying to, find new hires. And, there's even compliance attached to employees who do not work for your organization yet, which kind of seems hard to comprehend, but they're really every phase of that employment relationship is going to be governed in some regard. So again, we want to, the responsibility of the owners, executives, and management. You're as an organization, when it comes to HR compliance and proper compliance, you're really only as good as your management team. Not only do managers have to act within compliance or manage within compliance, they also have to be consistent among each other. And I know that this is a constant struggle for HR professionals and executives to kind of drill that into your management team. You know, Managers often think, if I'm likable and I manage, my employees and they respect me, then I should be good. But unfortunately, it's become far more technical than that. And looking at employment law compliance too, when working with our clients, we understand what they have to adhere to on the state and federal level, depending upon how large they are as an organization, meaning employee count. That's really the metric that's used to determine, you know, what laws you have to follow. So we know how many employees, how many locations that you have, what states you're located in, what is your industry, then we know exactly what laws that you have to adhere to on the state and the federal level. So make sure that you're constantly researching this, because it's a moving goalpost, as we all know. So make sure that you're staying on top of this to make sure just to ensure that something doesn't come across that you weren't aware of and it's already been implemented. We joke all the time that, the Department of Labor is not going to knock on your door and say, "Hey, this is coming down the line and this is going to affect your business." So ultimately, the responsibility lies on you to make sure you're aware of that. So just stay on top of it as best you can. Now, supervisors, yeah, and again, I've already touched on this several times, and we do this because we understand that, if you want to mitigate, HR compliance risk, then the best route to do that is through your management team. It's a professional responsibility of all supervisors, whether you manage one person or 5,000. It really is. It's when you're a supervisor, it's more than a title, it's more than a pay bump. It also comes with that professional responsibility. So please make sure that your managers understand that and instill the importance in them. And supervisors are critical again. Not only do they have to act within compliance, they have to be consistent. And if you have multiple locations, this can be fairly difficult to manage. If you've got 5 or 6 locations where you have a manager at each location, they're not around each other all the time. So it's hard to maintain consistency or, you know, having each manager manage, consistently across the organization. So, look into that and find measures or strategies that you can implement to monitor that and ensure that they are compliant. And there's a personal, liability for noncompliance. It used to be that, the company would take the brunt for any claim that was made for, by, I guess for being out of compliance, whatever that claim may be, made by an employee. But nowadays we find that cases come across to where they name the organization and the executive and the direct supervisor. So this is sort of a shock sometimes when we tell supervisors this, that, they have always thought that they were sort of protected by the corporate veil. But that corporate veil has been pierced. So as many people that can be named on a docket, that, attorneys think that is more productive for them. So it's key for supervisors to understand this. And
Yeah.
again, consistency. is the key.
Yeah, and can I say something, Josh, about this too?
Sure.
You have to look at it too from a culture standpoint. So if you have managers, holding people to different standards, your employees are going to see that, and that's going to breed maybe some resentment or some, why is this manager letting their employees do this, whereas this manager is just maybe following the handbook, or whatever you have that. But making sure that that consistency is key because it is so crucial to the culture within the organization of the employees.
Yeah, you are exactly right, Ashley, and that's, any type of inconsistency in HR is deemed discriminatory, because anytime there's any type of disparate treatment between one employer and another or a group of employees from another group, whether it's intentional or just accidental, perception's really all that matters, when it comes to what the employees think of the company and their managers. So again, like Ashley said, consistency is the key to make sure that you have got the culture that you want to achieve within your company. And we find, when you talk about, discriminatory behavior, and I think that that's just inconsistency in general. We find that oftentimes, when there's claims of discrimination or you have an employee that's upset, oftentimes it's actually not intentional on behalf of the manager. It really is just probably bad management skills. But what that equates to, or what that is perceived as, is I'm being treated differently, and it must be because of fill in the blank. And we never want to be in that situation, because what that's doing is that's slowing us down, from revenue generating activities that we normally can do for the company. So excellent point there about culture, Ashley. Okay, to jump into the overtime ruling, I'm sure everyone on the call is very familiar with the FLSA's recent increase to overtime eligibility for employees. As you know, there was an increase back in on July 1st that raised the weekly salary threshold for salaried individuals that were going to be eligible for overtime. And there's also a second tiered increase that we'll get into a little further, that is scheduled to occur on 1/1 of 25. Now, granted, there are challenges right now that are being heard in federal district courts. So we want to closely monitor that. Just a reminder that, prior to the last increase in 2019, in 2016, we were in a very similar situation that we are today, to where there was a scheduled increase to occur in the latter part of December of 2016. 1 week prior to that implementation date, it was stayed in the same courts that is being challenged in right now in Texas. So just a little bit of history there. We may see similar situations play out, but that's what we're going to closely monitor. So the old non-exempt versus exempt. I smile here because non-exempt versus exempt has been around for a long time. It really has. But I think that it could be the most widely misunderstood aspect of HR. I really do. And just talking with, our clients, whether they're owners or executives, I bet about 90% of who we speak with really aren't aware of the details of non-exempt versus exempt. And truthfully, or in my opinion, I think that the name non-exempt versus exempt is confusing in itself. But what we want to reiterate today is this is very, very, very important to understand. And if you don't understand, then reach out to a professional that can help you. And the reason we say that is because the repercussions of being out of compliance when it comes to this aspect of wage and hour, um, they're very serious. We never want to be caught in a situation where we have improper classification of employees because the the penalties and the money that is owed when you're found to be out of compliance is extraordinary, and for certain size businesses, this could be detrimental to the existence of a business, if there is egregious infractions that have occurred. But make sure that you understand non-exempt versus exempt. And one of the more important parts, and I'll go ahead and move forward, is I think there's several misunderstandings when it comes here, and you're probably aware of this too. That there's a common belief that salaried employees are not owed overtime. I think that's probably the most popular misconception out there. But when it goes a little further, it's actually a 2 or 3 part test. One is the first part is the employee paid on a salary basis? Well, if that's the case, then you would go to the second part of how much is that employee paid. So as of July 1st, we had an increase to that weekly amount. So right now, you will want to make sure that if you have an exempt employee, that not only are they satisfying of being paid salary, they have to be in excess of the new threshold for July 1st. Also, they have to meet the duties test. So don't just stop with the compensation part of the test. Make sure that you look at the compensation plus the duties test to determine if they are in fact exempt. And the duties test, unfortunately, is where it gets very complicated. You know, um, just when you think that, okay, we've got 6 categories of exemptions. This should be fairly easy to interpret, just like everything else with the federal government, or state government rather. Um, with the federal government, there's always going to be a lot of gray area, and so when you're doing your analysis to determine, you know, how many of my employees are affected, and do they fall in these exemption categories or classifications? Um, when you're looking at executive, and this is just a note that you'll see at the bottom, executive or management exemption is probably one of the more popular, because an employee, as long as they meet the compensation requirements, can be deemed exempt if they manage 2 or more employees. So that's about the easiest to interpret when it comes to these categories. But when you get over to administrative, just to be frank, it has nothing to do with administrative positions. It's actually someone who can make decisions on their own that will affect the financial integrity of the company. And rarely are you going to find an employee that really has that authority. So, what we would encourage here, and you'll see that we have a link to the fact sheet from the DOL outlining each exemption category. Do your best to do an objective analysis, and don't try to necessarily force or make that position fit into a category. Make sure that it legitimately does fit there, because ultimately um, we don't want to place an employee or a position in a category where they really don't qualify for. Where that category, by definition, would not have that position as exempt. Um, Outside sales personnel, that's another one that, while it seems black and white on the surface, it's actually a little tricky too. Kind of a general rule of thumb is, if an outside sales person spent more than 50% of their time in the field, then they could be deemed exempt. Um, Now, granted, there's a lot of sales positions that are not going to qualify for this, because by way of technology, your sales personnel does not necessarily have to be in the field as much as they did in years prior. So if you have, sales teams that are, for a majority of the time, are on webinars or web meetings, then they're probably not going to qualify for this exemption category. So that's just an example of, kind of the gray area here. So again, reach out to a professional to help with your analysis here, because you want to make sure that you're compliant in this area. There is no doubt about it. Now let's look at kind of what's happened thus far, and what we're scheduled, and the increase that is scheduled to occur on January 1st. Um, as you know, the increase that occurred on July 1st increased the threshold for salaried workers to 844 per week, which is equivalent to 43,888 annually. So if you haven't made adjustments in your organization or your business, then we encourage you to go ahead and do that now. This is already into effect. So we don't want to, the longer you take to make this adjustment or make these reclassifications or adjustments to compensation for those affected, the worse off you're going to be. And also you're butting up against a scheduled increase that's going to occur on January 1st, to where the weekly amount is proposed to be 1,128 per week, which is equivalent to 58,656 per year. Um, and I know that with the attendees on this webinar right now, that when you sort of look at those, if you're like me, that seems is sort of shocking, because to have within a 6 month period to go from 684 to 1128 weekly, that is significant, and not only significant in the volume of the increase, but significant in how many employees actually fall within that range. So this is affecting what was proposed. I think the DOL was saying that it could affect 4 million employees nationwide, but truthfully, that's probably directly affecting, but there's going to be peripheral effects for other employees. Say for the 4 million that are affected, and changes have to be made to those 4 million, that's also going to affect other employees that they may be butting up against, that there may be some salary compression issues. There may be two employees that are similar, but one's exempt or non-exempt at the time. So I think that it's actually going to, or we think as a team, that it's actually going to affect far more than the anticipated 4 million workers that the DOL has proposed. So, you know, make sure right now that you're doing your analysis, and we can actually jump over before we go into our recommendations. Another aspect of the final rule is there's going to be future updates every 3 years. And, this is done through fairly extensive studies. The DOL uses the BLR, or the Bureau of Labor Statistics, to determine, you know, where that level should be. It's a fairly complicated uh, equation that they use to get to that number, but it's based on the income levels of the lowest region of the United States, which is right now the Southeast. So make sure that you're monitoring this. We're recommending that going forward, you probably want to do an annual review, just so it doesn't sneak up on you every 3 years and you're kind of in panic mode, trying to do your analyses again. So, monitor this, but the automatic update every 3 years is something that's probably, while there may be some resistance to the January 1st increase, the every 3 year increase is something that's probably going to stick, in our opinion, because it's going to be in line with the last increase that occurred in 2019, which is a year later than 3 years, but it's going to be consistent with kind of that timeline. So the next update right now is scheduled for July 1st of 2027. So, how to prepare? I know many of you have already gone through, or you may have already gone through your analysis to determine, who is affected, and then there's others that may not have made this change yet. And like I stated earlier, we would encourage you to go ahead and make the change to adhere to the July 1st increase, but kind of put it on pause, and we'll go into it a little further as far as the January 1st increase. But what you want to do is you want to review the final rule and guidance. Make sure that you understand, what this law entails, and utilize the Department of Labor has fact sheets and information that you can reference to better help you define what those exemption categories are. So use your resources there and review your current classifications. How do you have your workforce classified right now? You know, Smaller organizations may not have many employees that are going to be affected, whereas by sheer numbers, larger organizations are going to have many more employees that are going to fall into this range. But review your current classifications. This may be something that may benefit you to include on your job descriptions, because when we're talking about classifications, do remember that this isn't necessarily about employees per se. This is about positions. So review your job descriptions, and maybe you want to include that, if that position is going to be exempt or non-exempt, so the employee is fully aware of what's happening, and you're being transparent about it. Um, but evaluate the impact on your business. This is sort of where it gets tricky. Again, when you determine, what employees fall in that range, to where they may have been a manager paid at $45,000, managed two or more people, so they're exempt right now. But when we go into January 1st, they would not be exempt because they would not meet the salary threshold or the compensation requirements. So you need to evaluate the impact on your business, meaning, if I make these changes, if I potentially give them a raise, how much is that going to cost the business? Are they working overtime? And there may be measures you have to take to determine if they are working overtime, if they haven't been tracking time before that. But evaluate the impact on your business as a whole to make sure that it's reasonable. And then again, watch for potential updates. This is something that we are closely monitoring. We've actually spent probably the last 8 months, talking about this. This has certainly been the hottest topic in past years, and we are monitoring even closer right now, because we're anticipating some sort of ruling on the January 1st increase, that probably is going to come within the next 45 days.
That's what we had a question out there that says, is there any buzz that the January increase may not happen? Because it is such a big jump. So have you been hearing about stuff that I know that you've touched a little bit about,
Hmm.
where it's at in the courts, but
Yes, that question is right on time, because we're actually now we're actually going to jump into that in 3 to 4 slides. What we have here. So if I can, Ashley, what I'll do is I'll explain that here shortly.
yep.
But perfect timing on the question. But what we've done here, and looking at the time that we have today, I'm not going to dive too deep into the next 3 slides, because we're going to provide you these as a reference as to some of your options when you're, going through your analysis. What are some of the options for those employees that are going to be affected? Do we increase the salary to maintain exemption? Option two, and each slide in these 3 options is going to show you the pros and cons, because there's certain things, like I mentioned earlier. Yes, we can raise salary, but we also need to make sure, is that reasonable financially for the company? Also, is that going to create problems with other employees who are maybe have more experience or tenure or more education? Those measurable things that can justify a difference in pay. Are you gonna, if you make an increase to someone from, let's say, 50 to 59,000, so they can maintain their exemption status? Do you have someone right now that's at 60 with far more experience, that now is there's not much difference in a pay with a less experienced employee? So it really is a rabbit hole that you can get down sometimes. But what these next 3 slides do is they really provide you with the options that you can take, and then what are the pros and cons of each one of these options. So I won't spend too much time on this, but the second option, position converts to non-exempt, and then overtime is paid. An example here to where uh, we actually, back in 2016, when we were doing an analysis with a community bank, we actually had employees that had worked there for 35 years that were going to have to start tracking time. And I'm not sure if anyone on this call has been through a conversation like that with a very tenured employee, but it's not fun. They will deem that as demotion. Even though it's actually for the benefit of the employee to make sure that they're paid at one and a half their hourly rate for any minute worked over 40 hours in that work week. But the employees do not perceive it like that. So there may be some morale issues that you've got to, make sure that you're conscious of, because you don't want to be caught off guard, especially with your tenured, most loyal employees. And then, another popular option is, instead of having to convert an employee to hourly non-exempt, you can actually maintain their salaried status, but pay them overtime for any time worked over 40 hours in that work week. Um, we've seen this be pretty popular because it's sort of a half step. Instead of having to change the entire compensation structure for that employee, they can still let them retain that salaried status, and then pay them for any overtime that's worked. Now, granted, this is probably going to require time tracking. So this is another hurdle that you're going to have to cross when it comes to communicating, this new procedure to your salaried folks. Having them, track time on a clock for someone who has not done that in the past is a big change, and they also sort of perceive that as a demotion as well. So make sure that you're positioning your communication to where it's most effective for the company. You can always lean on the fact that, hey, this is new federal law that we have to follow. This isn't our decision, but we're doing the best that we can for our employees to make sure there's the minimal change as possible. And going back to your question, Ashley, there are a lot of challenges to the January 1st increase that are occurring right now, and in the same federal district courts in Texas that stayed the proposed increase back in 2016. So I think that's very important. Now, granted, I think many of you may have heard that there was a case tried in Texas to where, before the July 1st implementation or that increase, it was found in a Texas court that state employees of Texas would be exempt from this law. So the increase on July 1st would not apply to state employees. Now that's just for public employees within the state of Texas. So private employers within the state of Texas, as well as all other states, are expected to adhere to the July 1st increase. Recently, there was a case in Mayfield versus the U.S. Department of Labor, to where the appeals court ruled that the DOL does have the authority under the FLSA to use a minimum salary as part of how it defines their exemptions. Now, the argument here is, yes, okay, there does have to be an agency that would propose a minimum, because that's kind of your starting point. But the true determination of whether an employee is exempt or not exempt is largely dependent upon the duties test. So you'll see in this third paragraph here that, yes, it was deemed that the DOL had the authority to set that threshold. However, the Mayfield case left open the argument that succeeded in 2016, arguing that the drastic increase in the salary threshold would effectively supplant the duties test of the EAP exemptions. So, such a large increase or a drastic increase over a short period of time sort of, takes the effect of the duties test out of the equation. So that's sort of what they're arguing right now. Now, when you look at, not just legal challenges, but there's a lot of other agencies and organizations that are also pushing back on this increase. SHRM, the Society of Human Resource Management, which is sort of sits right outside of the cabinet in D.C. It has not advocated for this second increase. You'll see here that Emily Dickens, the chief of staff for SHRM, says that while they would support reasonable increases or incremental increases over a period of time, the nearly 65% increase from the current level may not be in line with local wage rates. So what you have here is, if you've got a wide sweeping increase that is supposed to be nationwide, but we all know on this call that there's different compensation levels at different parts of the country. There's even differences in compensation, significant differences in compensation, even within the same state between rural and metropolitan areas. So to have such a wide-reaching, legislation just doesn't seem fair, for all that are involved or all that will be affected. So SHRM is one that has been pushing back pretty heavily. Another one is the United States Chamber of Commerce, which was pretty heavily involved in 2016 for that stay. So they have voiced their opinion on this, and they are advocating for the postponement of the 1/1 increase. This is Brett Coburn is an attorney out of Atlanta, and I thought that his recommendations were very easy to understand, and I thought that they were pretty much in line of where we are right now. But his recommendation is to determine which employees will need to get a raise to meet the new threshold and which employees will need to be reclassified. But he says, I would not implement anything or communicate anything to employees for the moment. And the reason he says that is, back in 2016, there was a lot of work done up until the latter part of December implementation date for the increase. Now, some of those, we had employees that received significant raises, and then 1 week prior, it was stayed in the courts. Well, you're not going to revoke that wage or that increase for that employee. So really, the only employers that benefited during 2016 were the procrastinating employees, or employers, those that did not prepare and did not, make any changes. So you'll see in the last quote here, he says, while I would not communicate anything to the employees at the time, I do recommend having a fully baked plan in place that will allow the employer to implement these changes quickly in the event that the court challenges are unsuccessful. So I think that that's a great recommendation. Go ahead and take the time now, to kind of develop your strategy so you're ready for 1/1. And if it does not, or if it's deemed, unlawful, or it is stayed in the courts, or invalidated, then you do not have to move forward with your strategy. But I would certainly be prepared in the event that the challenges are unsuccessful.
Yeah, and Jenica from my team, she had sent over some information during this webinar too, and she was saying about how there was a hearing held on 11/8, though it did not rule. Just know that it's still being talked about, but they're looking that he may rule very soon, possibly before Thanksgiving, which is coming up before we know it. So we'll keep our eyes peeled for that. And then one thing that I wanted to mention also, so making sure that you're utilizing iSolve for this. So reach out if you have any questions. Utilize Report Writer to grab, the status, the salary information that you have within the platform. So then you can easily pull that out of the system, rerun it. As Josh said, that these increments are supposed to happen every 3 years, so that you have those in place. And if you don't know how to do that, feel free to reach out to our customer service department, and they'll be able to either help make that report for you or really go into letting you know how to do so.
That's a great point, Ashley, too, because I think that within the ISOL system, you can actually indicate, and this is something I think that they've updated too, that you can actually indicate what classification that they are, whether they're exempt or non-exempt within the system. So as much information as we can put into the system, then the more efficient that the technology can be. So great point there. Um, Now, moving on to something a little different. We'll get away from that overtime issue here shortly, but you may have heard, through the press that about the Chevron doctrine, or what may be referred to as the Chevron deference. I won't get into the weeds here. I'll do this in my best layman's terms, but um, this is a 40-year precedent that was just overturned on June 28th of this year. And what this was courts were relying on the expertise of specific agencies. So if the DOL had proposed, a change for whatever it may be, if it was in court, then the judge would actually go back to the agency um, if there was any type of confusion or they needed interpretation on what was being proposed, and the agency who was proposing that would actually provide that interpretation. Now, while I understand the reason, a judge in a district court is not going to be an expert at everything. There's just no way. They hear too many different cases. But at the same time, law was being made by agencies instead of how law is traditionally made through the legislative branch of the government. Um, and as you know, also that the heads of these agencies are appointed by the current administration. So this can get political, at times. So this was a major, major decision by the U.S. Supreme Court. Potentially, I think this is probably one of the most significant changes that's happened in HR probably in decades. Because what this is going to do, it curtails the power of the federal agency and puts the power back to the courts, which makes sense, which does make sense. But now you're going to see, and let me just back up a little bit. We'll talk about this in a second, but you heard about a non-compete ban. That was proposed by the Federal Trade Commission, or the FTC. So that's something that's going to affect businesses, or would potentially affect businesses, nationwide. But it was proposed by an agency. So this is something where they're trying to get back to traditional legal interpretation by that respective judge or municipality which it's being heard in. So while this, I think, is going back to a more traditional way of legal interpretation, I think it will also create a lot of confusion for us in HR. So what we want to do is we want you to monitor legislation. It's going to look a little bit different than it has in years past. Not sure if this is going to create more HR legislation or less, but there's going to be a significant change. So this is something that we just wanted to put on your radar because this is going to affect all future legislation in regards to HR. So just please closely monitor this and research it a little further too, so you can make sure that you understand it. Speaking about that, many of you probably heard that there was a non-competition ban that was proposed, and the FTC was doing this to try to generate more startups, trying to take the handcuffs off of employees that could leave their potential businesses and then go start their own. Where they said that it was an estimated 18% of employees that were covered by some sort of non-competition agreement. Now, very quickly after that, and this was set to go in effect on September 4th of this year, but it did not take effect. Again, a federal district judge in Texas has issued a nationwide injunction setting aside the ban. So this is just an example, in my opinion, of how the courts and the agencies are changing their working relationship. So as of right now, this is still being heard in the appellate courts. So we're going to monitor this, but we don't see this going forward. This would be it actually would just be too wide reaching. Now at the same time, we're seeing a major transition, or we have in years past, from a non-competition arrangement to a non-solicitation arrangement for your employees, to where non-solicitation is going to be more specific to the clients within your organization. It's going to protect those clients instead of saying you can't work within this, you know, region or area selling our particular product or competing with us, because that was unreasonable. Families would then have to move to then be reemployed, and that was just deemed too wide reaching. So just an update here that was there was an injunction set on this ban. So as of right now, there is no ban on non-competition agreements. Very quickly, the employee versus contractor classification. This has been something that this is a very high risk area. And in March 11th of this year, the DOL actually reverted back to a previously used multi-factor totality of the circumstances analysis. And I know that that's about as clear as mud. I fully understand that, but there's actually these 6 bullet points are kind of how the DOL is looking at if a worker is going to be classified as an employee, W-2 employee, or a 1099 contractor. We find that some clients think that this is a decision that they can make. An owner executive said, well, we're just going to have them be a contractor. It's actually not the case. So you're going to have to go through this analysis. This analysis is not black and white. It's actually 6 metrics that are measured, and then it depends on which way that your worker is leaning. Are they leaning more towards being an employee or more towards being a contractor? And the reason you need to understand this is you don't want to be found in a situation to where you've had someone classified as a contractor when in fact they were an employee, because the employer would be responsible, I think, up to a 3-year look back period for all payroll taxes on behalf of the employee and the employer. So you're talking about, approximately 15% of those wages that were not paid, or excuse me, of those taxes that were not paid for the wages that were extended to that worker. There could also be penalties and fines attached to that if they found it to be intentional. So this is something that they're never going to look at one of your contractors. They're going to look at your entire workforce if this becomes an issue. So make sure that you're really shored up here, because the financial repercussions can be detrimental. The Pregnancy Workers Fairness Act. This actually took effect on June 18th of 2024. This is similar to the ADA, or American with Disabilities Act, in that it provides accommodations for pregnant workers or issues that are relating to pregnancy. So this actually could be medical incidents that occur as a result of pregnancy. So take a close look at the EEOC interpretation of this. And also a key point here is there are many states that have already enacted similar legislation, whether it be related to pregnancy leave, whether it be related to lactation, or any other type of accommodation. There are many states that already have this in effect. So in addition to the PWFA, make sure to research your respective state to make sure that you're following both, because there's going to be some overlap. There's going to be probably some redundancy, but just make sure that you're adhering to both the state and the federal compliance there. Now, some accommodations being presumptively reasonable, we'll touch on that very quickly. And allowing an employee to do something like carry extra water to drink as needed, or additional restroom breaks. These are things that you should allow your employees to do. I would assume that most people would do this, but you got to think sometimes schedules at work may interfere with these accommodations. Regardless, it's very important that you follow the PWFA to make sure that you're allowing these presumptively reasonable accommodations for your employees. So make sure to do your research here to understand what applies on the federal and the state level, because this is the type of claim you don't want to fight. You know, you never want to go into a courtroom because any judge or jury has a parent or a family, and there's not going to be much grace given to the employer in this regard. Let's jump on. So minimum wage trends, this is something that sort of surprised me this past year that in 2024 alone, 20 states increased their minimum wage. That is significant. Of course, we see trends that happen in more progressive states in HR, and sometimes that trend will remain in those progressive states. But for the most part, it's sort of it will trend nationwide eventually. And I think that you see that on this slide too. I mean, there's actually a growing trend among states to increase the minimum wage to $15 per hour. 8 states have already adopted that. There's three other states, Delaware, Illinois, and Rhode Island, that are set to be $15 an hour by January 1. And then the last bullet point here sort of shows you how that trend is moving across the nation. Because these 3 states, Florida, Hawaii, and Nebraska, where Florida and Nebraska tend to be more employer friendly. But they already have scheduled increases to occur in 2026. So this is just kind of, justifying that it's coming, so make sure that you understand what your state is doing, because it looks like the federal government's kind of pushing this responsibility down to the states to govern, which may make sense because you've got different parts of the nation at different compensation levels, or income levels, excuse me. But when you see a trend like this, make sure that you're paying attention to it. Also, when you have remote employees, make sure that you understand the compliance, for minimum wage in that respective state. It can be easy just to think about everything where you're corporately located, but it is critical to understand that if you have a dedicated or remote employee, we've got to understand everything about that state compliance too. So pay transparency laws. This is another trend that we're seeing come about, and making pretty quick traction, nationwide. And we all know that pay transparency laws, the initiative was to address pay inequality and promote wage transparency, because it requires employees to disclose compensation information and increasing employee access to salary data. While this sounds great, we all know that being involved in HR, this is kind of a nightmare, to transition from how we've traditionally managed, this aspect of HR moving forward. So, and these laws vary in their requirements, but often require employers to post salary ranges in job postings or disclose salary information to existing employees and job applicants. We still have clients that contact us and are upset. Sometimes they're owners of companies of substantial size, and they become very upset when their employees are talking about their pay. And we have to explain to them that, federally, that's actually protected as a concerted activity. Not only that, it's probably not going to be too long before we're looking at where we have to advertise this information, such as a state agency would, to where everything is public. So while we may not agree with this, it's coming. So make sure that, again, if you're hiring remote employees, they may be subject to pay transparency laws in their respective states. So make sure that you're looking into this and completely understanding, what each state requires. Because not only are the laws going to require, pay transparency, each state's going to be unique to its own, as how that law is going to be interpreted or implemented. So with all that, I know it's a ton of information, but Ashley and I wanted to just briefly mention, kind of how we work with clients, and is HR consulting a good fit for your organization? And we find that HR is more technical than it ever has been right now, and we're finding that clients are reaching out for guidance, and that's why that years ago Dominion Payroll actually developed a program called the DP Boost HR program, and Ashley Smart has done an excellent job. She manages this department or line of business, and what we do is we partner with organizations like your own,
Mhm.
and we are a resource for them for all things HR. It's very difficult to kind of keep up with what we talked about, that moving goalpost of what are we required to do as a business.
Mhm.
What's coming down the line.
It
How do
takes
we
so
navigate?
much time to
Oh
really
yeah.
research that. A lot of time that our clients don't really have to spend on HR, let alone everything that the government puts out is pretty much clear as mud. So it's very hard to understand. And so that's what, with this program, like we said, we'll send you the slide deck here, so you'll see this. But if you have any interest at this at all, you see anything that sort of catches your eye, we're there to be that resource for you. Reach out to Josh, and he'll be able to point you in the right direction with sort of having those initial conversations of, is this a good fit for your organization?
Yeah, I think that Ashley is and her department. They've really done an excellent job with this over the years, and we've seen that our client engagement has grown significantly. And one of the neat things that I think is a part of this service is not only do you have a dedicated HR advisor that learns about your business and develops a relationship with you and your company. I think one of the best parts about this too is we kind of give business owners and executives that rest assurance that they're doing things correctly. You know,
Mhm.
um, Having that uneasy feeling or not knowing what you don't know is not a good way to move forward. That doesn't give anybody that warm and fuzzy feeling. And I think one of the neat parts about the business or this service too is we actually do a pretty extensive assessment. When we first engage a client, a Boost client, and that helps to identify or benchmark where we are right now, where your business is right now when it comes to state and federal compliance. And then we help to develop a roadmap of how
Mhm.
to shore up compliance. So I think that really gives owners and executives that confidence to effectively manage their employees.
Mhm. Yeah. And one thing, 'cause I know that we have just under 2 minutes left here. We did have one question that came in regarding, I think it was back on the FLSA duties test. The question was, should employees working from home also be held to these rules as well?
Yes, and very good question. And yes, they will be held to those same rules. The work location is really not going to influence proper classification. So you'll want to make sure that that employee, you're treating them the same way that you would your employees that are in house or own location.
Mhm.
So that's a very very good question, but yes, unfortunately they're going to be treated just the same as the remainder of your employees.
Yeah. So thank you, Josh, so much for all of this information that you shared with us today. Like I said, we will be following up with the presentation, the slides. So we know that compliance can be very tricky. It's not everybody's strong suit. So that's what we're here for Dominion Payroll. And we want to thank you guys so much first for being clients of Dominion Payroll. We appreciate you so much. That's what this week is for, really appreciating your relationship with us, as well as being our partners within HR. So thank you guys so much, and I hope that you have a great rest of your day.